Good morning. My name is Jennifer Locke with River Rock Law. I am a wills and estates and real estate lawyer in Edmonton, Alberta, and welcome to my YouTube channel. Today I wanted to talk a little bit about something that most people are caught off guard by, and that's that you need more than just a will. You need two other documents called a power of attorney and a personal directive. Specifically, an enduring power of attorney allows a decision maker that you name to make financial decisions for yourself while you're alive but mentally incompetent. A personal directive allows a decision maker to be appointed to make, of course, healthcare decisions for you while you're alive but mentally incompetent. And so together with the will, because the will only takes effect after you die, that is a full comprehensive estate plan. So you really need all three documents. Now, the feedback I usually get from clients is a bit of surprise, because usually they're saying to me, well, can it just be my next of kin? Isn't it my spouse? Isn't it, my adult children? And the answer is no. Next of kin only gets you so far. So issues that I know, like myself personally, I've run into is, thankfully, my mom, when she was declared to have early onset dementia, the geriatric psychiatrist that we dealt with said, okay, she still has capacity. You need to get out there and get a power of attorney and a personal directive done ASAP, because she's losing capacity. It could be gone in 6 months, a year, 2 years. Get these documents done now. And we're glad that we did, because eventually when we had to move her into a long-term care facility, it was the personal directive that allowed us to do that. In fact, we couldn't even get a meeting with a social worker and with a transition coordinator until we proved that we actually had a personal directive and a doctor had put it in effect. Didn't matter that we were family, didn't matter that my dad was still alive, none of that mattered, okay? So if you think about it from kind of a societal perspective, think about how many divorces there are, think about how many separations there are, think of how many parents or children, adult children specifically, might be estranged from their parents and children, vice versa. So you have to take that into consideration, that these documents were created by our legislator drafters to ensure that we as autonomous individuals can give power to people that we think are right for the job, that we know that are going to take care of our finances, that are going to make sure that we're transferred to the right facility if we can't stay in our own home. So I wanted to just talk to people about that. Yes, generally speaking, if there's a spouse, and you have a lot of joint accounts together, most spouses don't encounter too many issues when it comes to dealing with finances. But where they get caught off guard is now having to deal with the personal decisions, such as placing their loved one in a long-term care facility, and are completely surprised that they don't have the authority to do that without it being reduced to a personal directive. So that's my little clip for today. Hopefully you find this interesting and helpful. If you have any questions at all, of course, don't hesitate to reach out and visit my website at www.riverrocklaw.ca. All right, everyone, take care. Have a great one.